The draft decision of the US Supreme Court has been circling the news for quite some time now. And so I took the liberty of reading the entire decision, and I'm gonna tell you what you need to know about it. I know this news has created a lot of frustrations, uncertainty, anger, resentment, and criticism. And so I'm a firm believer that before one criticizes anything, one must first learn it and understand it. And only then can one be in a position to criticize adequately. There's several things to keep in mind throughout this video. One of them is this is a draft decision, which means, right, operative word is draft. Nothing is set in stone yet. Second, we don't know how Chief Justice Roberts is going to decide in this case. We don't know if he's going to disagree with Alito or agree. We just don't know. We don't have that information at this moment. And third, for whatever reason, Roe v. Wade and Casey are overturned, you can rest assured that there's going to be dissents on this matter. This issue is very controversial. As a result, there's always going to be a split. The reason dissents are important is because it can lead to a marginal win, and if that's the case, it potentially leaves the case for a potential overruling sometime in the future. And so before we continue, I would just like to say that I'm not a constitutional law lawyer nor a scholar. I'm simply an attorney who has taken the liberty of reading the decision and would like to inform the public about it by breaking it down so that way they have adequate information about the matter. Our legal system is based on precedent, which is pretty much legalese for pre-existing judicial decisions. And so courts must follow the doctrine of stare decisis, which is Latin for stand by things decided. The doctrine of stare decisis is essentially cases with similar issues should be decided alike. Therefore, the past informs the present. The doctrine of stare decisis is important because it promotes stability in the law. And if there's stability in the law, then there's stability in society. And the doctrine also helps ensure the legitimacy of the judicial process in this country. Although we follow this doctrine of stare decisis, where cases with similar issues should be decided alike, such a doctrine is not absolute. Courts can overturn prior decisions, and in fact, they have done so. When doing so, they could only overturn a prior decision under a special justification. So from my research, the US Supreme Court was established in 1789. 21 years later, the Supreme Court overturned one of its prior decisions, and that was its first overruling decision. And so from 1810 to 2020, the US Supreme Court has overruled approximately 233 decisions, and it has decided an approximate total of about 7,736 decisions. When we take those numbers, the US Supreme Court has only overruled 3% of its decisions. So the US Supreme Court has identified several factors that are relevant when determining whether to overrule a prior decision. Some of the relevant factors include workability, reliance, abandonment, legitimacy, and also the nature of the case's error, the quality of the case's reasoning, and the disruptive effect that such a case has on other areas of the law. Through my research, I discovered, and it is my understanding, that these factors are not absolute. One factor is not more important than the other, and these factors should not be considered in a mechanical manner. So it's important to keep in mind that these factors are essentially like guiding principles. The court doesn't apply these factors in a mechanical, rigid format or manner. So the draft decision is dealing with a Mississippi law called the Gestational Age Act, which prohibits elective abortion if the fetus has a probable gestational age that is greater than 15 weeks. The draft decision considers the doctrine of stare decisis and whether or not it should overrule binding precedent, that is Roe and Casey. And for that, it actually analyzes several factors, and it determines that these factors favor heavily in overruling Roe and Casey. Going in the order of the draft decision, the first relevant factor is the nature of the case's error. And here, the court determines that Roe incorrectly interpreted the Constitution. And I quote, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. The second relevant factor that the draft decision considers is the quality of the case's reasoning. And here, the draft decision claims that Roe did not base its decision in any text, history, or precedent. As the decision states, Roe found that the Constitution implicitly conferred a right to an abortion, but it failed to ground its decision in text, history, or precedent. And then it goes to list several reasons to support its claim. First, it relied on an erroneous historical narrative. Second, it devoted great attention to and presumably relied on matters that have no bearing on the meaning of the Constitution. 3, it disregarded the fundamental difference between the precedents of which it relied and the question before the court. 4th, it concocted an elaborate set of rules with different restrictions for each trimester of pregnancy, but it did not explain how this code could be teased out of anything in the Constitution, the history of abortion laws, prior precedent, or any other cited source. And it goes on to list a few more. The third factor that the draft decision considers is workability. And the parameters around that factor is essentially whether or not the rule of law can be understood and applied consistently and in a predictable manner. What they're getting at is whether or not the law is uncertain, unclear, difficult to apply. And so this draft decision claims that Casey's undue burden test is unclear, uncertain, and that lower courts had difficulty in applying that test, mainly because it's surrounded by 3 smaller subsidiary rules containing vague terms, different standards that overlap with one another, and the draft decision makes it a point to note that it has applied Casey's undue burden test differently on subsequent cases. The fourth relevant factor that the draft decision considers is the disruptive effect the case or rule of law has had on other areas of the law. And here, the draft decision considers and claims that Roe and Casey have had a disruptive effect on other areas of the law, principles, doctrines, standards that are usually found in constitutional analysis. Without getting bogged down on the details too much, I just want to quickly point out that this is, interestingly enough, the shortest section of the opinion. The fifth relevant factor that the draft decision considers is reliance. And the parameters around that factor are what are the reasonable and justifiable expectations that people are having with the rule of law. That essentially, how heavily do people rely on the type of law that we're dealing with? And here, the draft decision makes it a point to stress that, like in Casey, it agrees that abortion cases do not have the traditional reliance interests that are usually found in fundamental right analysis, which are more concrete facts. They stress that the type of reliance interests we are dealing with when it comes to abortion cases are more intangible. And so because they're more intangible, they're much more difficult to ascertain. The draft decision ultimately claims that the court doesn't have the proper tools to really assess those intangibles that are at play here. Then the court goes on to speak about legitimacy. And when we're dealing with this factor, we're dealing with the question of whether or not the court will lose its integrity or legitimacy in overruling a prior decision. Quoting from the actual decision, it is important for the public to perceive that our decisions are based on principle, and we should make every effort to achieve that objective by issuing opinions that carefully show how a proper understanding of the law leads to the results we reach. But we cannot exceed the scope of our authority under the Constitution, and we cannot allow our decisions to be affected by any extraneous influences such as concern about the public's reaction to our work. What the court is saying is we're sensitive to the highly controversial nature of this issue. And this draft decision firmly believes it's interpreting the Constitution correctly and they're not doing anything improper by overruling Roe and Casey. Interestingly enough, the draft decision doesn't even get into abandonment. And when we're dealing with this consideration, we're dealing with the question of whether subsequent cases have gone in a different direction, leaving the old rule of law obsolete. Here, I think that they didn't even get into relevant factor of abandonment because you're having courts still figure out Casey and Roe, and sort of like, I guess, in the eyes of Alito and everyone else who agrees with the draft decision, struggling with these rules that are implemented by these cases. And so instead of going in a different direction, right, lower courts and even the US Supreme Court, according to the draft decision, is still, trying to figure out the proper interpretation of these rules and application of these rules. Even though abandonment is a relevant factor in the stare decisis analysis, it's not relevant here because no court has chosen to abandon that rule of law as of yet. Now that we've covered a multitude of aspects of this draft decision, I just want to leave you with a few key takeaways. The first one is, like I said in the beginning, this is a draft decision. Nothing is set in stone until the decision is actually published. Things can change. Secondly, interpretation can be a tricky and slippery exercise, and it's very difficult to understand for some because it's very nuanced. Take, for example, constitutional law and the US Supreme Court. You have some justices who have a strict interpretation of the Constitution, and you have other justices who have a more liberal interpretation of the Constitution. And then you have other scholars, constitutional law scholars, who disagree with both of these approaches, and they have their own approach. So as everyone interprets things differently based on experiences, upbringing, education, life, who's to say which one is correct objectively, right? And so that's what makes interpretation very tricky and burdensome. And so people, as we all know, like to say that attorneys are liars. My favorite response is most of us are not necessarily liars. It's just that clients leave things up for interpretation. 2-3 people can see the same event or read the same paragraph and have 3 different interpretations about it. So that's what makes interpretation so tricky. Lastly, if the court is going to overturn Roe and overturn Casey, it needs to make sure it has a special justification that is grounded on legal doctrine. And it cannot even have a faint smell of political bias or have it based on political pressures, because the US Supreme Court is supposed to be an apolitical institution. Any whiff of political bias or any bias in general, it's going to dilute the court's credibility, integrity, and legitimacy in our society. And then who knows where we go from there. Ultimately, the draft decision prefers that the states regulate abortions however way they see fit. That being said, the point of this video is to provide you with the cliff notes and accurate information about the contents of that draft decision, so that way you're more informed as to the analysis that is circulating the news nowadays. My name is Will Trevino from the Trevino Law Firm. I hope this video has been informative. I'll be following this situation closely as it unfolds. In the meantime, feel free to leave your comments, questions, concerns down below. We'd love to hear from you. Peace and love.